So for the ones who do not know us, Drummond Advisors, we are specialized in cross-border transactions, mainly tax, accounting, legal. So anything that crosses the border, we're on it. So our clients are mostly companies from Latin America and around the world doing business in the US. And we also assist foreign companies going into Brazil. Today we have my friend Daniel Paiva here, who is a tax lawyer, specialist in crypto assets, blockchain. So I'm gonna let him introduce himself, and also Camila Cabral, who is our senior tax consultant. And I'll let Camila say a few words as well. And let's get started. Danielle, thanks for joining us today. Very nice to have you here. And if you don't mind, give us a brief overview of what you're doing, and then your perspective for today's webinar, please.
Thank you so much, Michel. It's a huge pleasure to be here with you. For those who are here as attendees, I got to know Michel and Bruno on Step Latam last year in Panama. It was a very amazing experience. And they are, despite the distance, right? We are friends, and we have been developing some discussions now and then. And because of that, I'm really glad to be here, especially because this is an event and that we can bring together different perspectives from what Drummond Advisors have been witnessing in the past few years, and alongside in partnership with VDV, my law firm here in Brazil. And for those who don't know me, my name is Daniel de Paiva Gomes. I am a tax lawyer focusing on financial markets and Web3. And I have besides my professional background, I have an academic research field focusing since 2015 on crypto, Web3, tokenization, metaverse. I'm the author of the book, Bitcoin, the Taxation of Cryptocurrencies, and the author and coordinator, alongside with Eduardo de Paiva Gomes and Paulo César Conrado, of a collective book called Crypto Assets, Tokenization, Blockchain, Metaverse, Philosophical, Technological, Economic, and Legal Aspects, both published by Thomson Reuters editors here in Brazil. And basically, I have been studying these new technologies and the way they interact with law in my master's, and also in my PhD that I'm supposed to conclude next year in the Pontifical Catholic University. And to get a broader overview about this phenomena, these different phenomena in the Web3 ecosystem, I'm finishing my master's in science and computation on blockchain and digital currencies on the University of Nicosia, in order to bring interoperability at the end of the day between legal plan and business plan, and make everything flow the most easier way possible. So Camila, please, the word is with you.
Thank you, Daniel. Good afternoon, everyone. It is a great pleasure to be here today with you all. I'm a tax consultant here at Drummond. I'm a lawyer. My fields of expertise are tax and international tax law. And I'm a part of the tax planning and transfer pricing team. Not the super expert in crypto and Web3 like Daniel, but I've been working with Drummond and cross-border projects for the past 3 years. So we're looking forward here for the discussions today.
Thanks all. Guys, I'm excited about this webinar. I mean, particularly I have an interest in the topic since, since the early days, not so early, but that's something that's always intrigued me. And I know Camila for a fact, she also likes it, and she has, she likes to talk about NFTs and some of the DAO projects and so on. So we're gonna hear from her on the sides, her side projects. But let's get started. Daniel, if you don't mind, I mean, since we have a broad audience today, give us a quick overview of, now we all hear the term 3.0, Web 3.0, and this, companies that are based on blockchain. And if you can, look at back and kind of like from your perspective, what are the main differences that we see when we compare 3.0 and 2.0 startups, like in the, especially on the tax side? What are the main challenges and the differences between these kind of like the next stage or the next generation of companies?
Great. It's a great question, Michelle, and a very difficult one to give maybe assertive answer. For those who have been following me, there is something that I used to say is that everything has changed and nothing has changed at the same time, because I see tokens in a way very similar to like Liechtenstein. They talk about tokens as containers of rights and assets. I feel that sometimes we are only focusing on the form token, a fungible token, a non-fungible token, and we are not focusing enough on the content of these things. So at the end of the day, if I have, for example, a physical flight ticket, then I have an e-ticket in my cell phone. If this flight ticket becomes an NFT, what has changed? In my opinion, nothing. From the tax perspective and from the regulatory perspective. We have some difficulties, I would say, regarding the native Web3 phenomena. For example, mining, Bitcoin, DeFi, things like that, because we are changing the perspective of the interactions between users. In the past, in a purely Web2 perspective, we were talking about user-to-user interactions. For example, in social networks, or if we may have a holistic view from Web 1, Web 2, Web 3, we are evolving from static to creator economy, but the owner of your data are the big techs on the Web 2. And then in Web 3, we are empowering users. And this empowerment comes together with this idea of Web3 native phenomena. So the difficulties or the differences between Web2 and Web3 startups remains focused on the startups that are dealing with this new and disruptive phenomena. But in other cases, for example, when you have a collectible that is in a form of token, for me, this does not differ at all from a card that is a collectible. So if you have a trading card game, physically speaking, or a Web2 version of it, or an NFT, from the tax perspectives, all of them, for example, would need to collect capital gains if you are selling for thousands or millions of dollars. These days, I was reading some news about Yu-Gi-Oh! It's a trading card game, very old. A guy, when he was a child, he had cancer or a very bad disease, and the creator of Yu-Gi-Oh! Decided to create one card in the whole world for this child. And now many years have passed. He's an adult now. He decided to put for sale. He will make a bid, an auction in April, if I'm not mistaken. I'm sure that he's going to get millions of dollars. So what's the difference from these capital gains for selling NFTs? From a tax perspective, I don't see any differences at all. So the same reasons why Web2 startups need to have a good legal plan are the main reasons why Web3 startups need to have also a good legal plan.
Yeah, one thing to add, and correct if I'm wrong, and I feel very, that's something that intrigues me, and I like it a lot on Web3, is the shared ownership concept, right? Like, okay, if you have, let's say, Michael Jordan's jersey from a special game, and now you can sell a share of that, valuable asset, and then everybody, eventually, so there are different ways, right? But as an example, eventually when we sell that jersey, we all can benefit from, at some point, making an investment, especially if you're talking about a valuable asset that, over the time, I mean, this also works for arts and other industries. But so, as you said, the concept's not really, of course, like the way that we present it has changed, but this idea of sharing ownership and it's been there for a while, right?
I couldn't agree more, Michelle, because at the end of the day, we're having something that is more accessible, but the idea behind it It's, for example, when we talk about collective ownership, we have, for example, cooperatives, and cooperatives are there for a while, and no one was talking about them until now. So what is the difference, pragmatically speaking, if I have a DAO of web developers or if I have a cooperative of web developers? What they are doing in the physical world are the same thing, the activities performed. But that is why I sense that this idea of Web3 is more about empowering people about their own data, and maybe creating new and faster and international and global perspectives of doing business. For example, to raise revenue or fundings for a new Web3 project, publicly speaking, you would need an IPO. But now, if we are talking about purely utility tokens, you could do that by an ICO, initial coin offering. So we have this new phenomena that they differ from Web 2 perspective, and they are also shaping our worlds. But I agree with you. The idea behind all of these things are the same, and they are here for a while now.
Awesome, Daniel. We already have a question here from Thiago. Thanks, Thiago, for participating. So, I mean, I'm gonna read the question here, and then Camila, also, if you want to jump in, feel free. But I think that's directly to Daniel, and then we pass along to Camila. What's the impact of the popularization of crypto as a service on the adoption of cryptocurrencies and the security of online financial transactions? So I think we're going to cover a little bit about, security regulation and as we move forward here. But Daniel, if you want to give your input here, feel free.
Sure. I would say that crypto as a service, we need to separate if this service provider of crypto as a service will be or not qualified as a virtual asset service provider. Depending on the local regulation, the answer to this question will be yes or no. So the bureaucracy related to providing crypto as a service may be highly affected by this answer. For example, I could have nowadays, I could hire a studio to develop a game for me. So if I do that, the ownership of the intellectual property is mine, is from my company. But I have a game as a service company doing that. Imagine that I have a only private relationship between my company, that is an exchange, a crypto exchange, and then I am hiring a white label, a company that will provide crypto as a service for me. Who would be held liable for any kind of damage caused to third parties, to the users? In my opinion, my company, the exchange, because from the user's perspective, this is what's going to be seen. But of course, if this is an issue on the code, is a flaw on the provision of these services regarding the company that I hired for a white label for a crypto as a service, my company has the rights to pursue and have the damages received back to my company because this service provider, this crypto as a service provider, made mistakes. So we need to understand when we talk about crypto as a service, if this company is or not qualified as a virtual asset service provider. And very important here, we may have to deal in a dual perspective. One perspective is the place of incorporation. The other one is the jurisdiction of the users that are affected by any kind of public offer. So we cannot be naive and think that because I am placed on, for example, Seychelles or Dubai, that I can do anything I want. No, you need to understand that you need to be in compliance with also the local jurisdiction where you're targeting. And when we think about security, we need to split. Am I talking about security from a technological perspective? So if this is the answer, yes, I have all the provisions from ISO standards regarding benchmarks of excellence regarding technological things that should be implemented in any project, regardless Web3 or Web 2, to ensure security in these transactions, in these operations. Other thing completely different, and I'm answering in a dual perspective because I don't know what is the answer here exactly. When we talk about security, we can have securities legislation issues, as pointed out by Michelle, and to know if the tokens offered are or not qualified as security tokens, utility tokens, payment tokens. This is not a mere question about should I be submitted to the Securities Exchange Commission or not. This can affect also the taxation. Just to give an example, payment tokens are not submitted to VAT in Europe. But if you have utility tokens and NFTs, depending on the content of these tokens, fungible or not, we may have the collection of VAT upon these transactions. So securities legislation is a issue that we have not a unique and closed answer for that.
Great explanation, Daniel. Thank you so much. Camila, let's get started. So I would love to hear from you from the legal and tax perspective. What are the challenges you are seeing on Web3 companies nowadays? I mean, with everything that's going on, what are the main challenges that you're seeing on a day-to-day?
Well, Daniel gave us a great background of what Web3 is and represents this disruptive technology that is challenging all the concepts we have for today's world. And since there is a whole new dynamic, new moving forms, parties of relationships, the governments, businesses, and individuals are already facing challenges and difficulties, and the things are just going to increase with time. We will all get used to the new reality, and like what happened with Web 1 and 2, the law may be the last one to go along with it, maybe because lawmakers are not very much used to this world, maybe because relationships change way too fast. We just have to go along with it while we're here. And in what relates to challenges, which are many, we can mention here a few, starting with the not so sexy part of regulatory aspects, for example. It seems a contradiction to bring regulatory matters to a completely decentralized environment, but laws and regulations were born for some reason. In Web3, metaverse, we still have the element of society. We have people operating their computers and manifesting their actions through them. We have financial transactions in the blockchain. We have one party selling to the other. We have people getting along to work on a project. And we have the social element. It's just virtual. But in a decentralized environment, with no point of control, it is quite challenging to apply the laws and regulations we already have designed to the real world, in which, as much as we have issues with digital economy, geography still plays a major role in our real world. So we have the SEC struggling to enforce security laws, as Daniel explained, on initial coin offerings, for example. We have tax authorities with difficulties enforcing their taxing rights on projects that are based in a jurisdiction and managed by users in other. Also, as much as the decentralization is designed to be fair and clear, and people are supposed to control their own data, wrongdoers cannot be ignored. So how and where to hold these people accountable for legal matters can also be a major issue. For example, let's suppose we are all working together on a project through a decentralized autonomous organization, also known as DAO, DAO. DAOs are actual organizations in the blockchain environment, and the control of these organizations relies on people using their computers around the globe, voting and engaging in activities. And in the blockchain environment, everything is operated through smart contracts, and the rules encoded on these contracts with the respective record afterwards. But there is no central decision. It's a process of consensus involving the members of the DAO. So if some user involved in the DAO project uses the intellectual property of another user in an NFT, for example, without permission, without having acquired this intellectual property, the owner of this intellectual property may hold this person accountable. At least according to the laws of the real world, it is possible. In this example, we are facing the challenge of accountability of the wrongdoer by a DAO or the owner of the intellectual property, the challenge with the attribution of intellectual property rights to the NFT, what can be considered an original in the digital world, for example, and how a real person or entity can be protected from liabilities originated by a DAO. In benefit of time, I want to bring up another point regarding the DAO and ask Daniel to contribute with his perspectives, because one thing that comes to mind is, does a DAO have legal status? What would be the tax treatment of it? What would it be attributable to a real jurisdiction? It is something that governments have been facing through time. So if you, Michelle, or Daniel have any perspectives on this matter, I think it's a great time for debate, because as if I'm not mistaken, Wyoming has acknowledged the DAO as a legal entity in the real world. So, but in the federal environment, it hasn't happened yet. So it's kind of blurry.
I totally agree with you, Camila, and I will be glad to hear also Michelle's considerations. I'm very skeptical about DAOs, and I'll tell you why. When we ask what is the legal status of a DAO, I would ask another question: what kind of DAO are we talking about? If we are talking about the most common type that we see on a daily basis on news, on Twitter, we have a group of people that get together because they have some kind of alignment regarding principles, mission, values, and then decide to work together in a project. But they have no entity incorporated anywhere. I would say that the legal status of these DAOs are general partnerships. And at general partnerships, I would say for those that are watching us, don't go through this path unless you are very aware of the tax consequences and the regulatory consequences of being involved in a general partnership. Because some jurisdictions, they consider general partnerships as pass-through entities, so they are transparent. And when we're talking about general partnerships, if they cannot hold all of the members of the DAO liable for the harms that have been caused, if they find one, this person will be held liable from a tax and criminal if we are talking about some kind of criminal sanctions. So it's very important to look for jurisdictions like this one that you mentioned, Camila. Wyoming has a specific law for DAOs. If I'm not wrong, also Vermont, they have the blockchain-based limited liability companies. And we have some kind of other entities that some DAOs are using. For example, if I'm not wrong here, there is the trust in the Guernsey Islands and also the Faceless Foundation in Cayman. Because at the end of the day, we have some obstacles when dealing with DAOs. For example, a DAO may need to hire or pay things in the Web2 world, in the physical world. So if you are purely on-chain, how are you going to pay this? Or how are you going to interact to sign a contract? Maybe this DAO, it's a Web3 developers DAO, and they are a big company like Coke wants to hire them to make an NFT collection for them. How they are going to sign this contract? No mainstream player will get in business with a DAO that cannot interact in the Web2 world. So even from a business perspective, DAOs need to have a hub, a conduit to connect with our world. I don't like to separate things between real world and blockchain world because I would be contradictory with my early statement when I said that everything has changed and nothing has changed at all. So at the end of the day, I would say if you have a group of friends making business online and you have no entity and you are receiving payments in fiat currency, you would have the same problem of having a general partnership as you have when you are dealing with a purely blockchain DAO. So I would say for protection of the users, for the protection of the founders of this DAO, I would recommend to search for a jurisdiction where you can have this traditional layer that would give a different legal status for this DAO. So we can face the DAO more as a technological way of doing governance than a separate thing that would have no connection with law at all. This way we can like have the best of both worlds in a sense. You can have the liquidity and the velocity, all the good things that a DAO can give us on the blockchain perspective, track record, immutability, things like that. And at the same time, you are protecting the founders of this DAO. You can give legal certainty for those involved in this project. And also you can give some kind of predictability for the users, because when you interact with some collective, a group of individuals, non-identifiable, the first thing you would maybe have in your mind is, am I being involved in a rug pull? Is this legal? Can I be harmed? Are they going to steal my assets? So when you have this kind of legal status, I think everyone benefits from it, you know? Don't know if Michel has the same point of view.
No, I totally agree. I mean, imagine being a partnership without the legal support of being a partnership, right? Like, so we all, you know, like doing something together, but we don't have the, I mean, just using the reference on LLC, for instance, like the limited liability company, you know, like you don't have that type of protection without a proper structure. So I think you guys went straight to the point. I mean, if you're doing something, you know, in the DAO space, make sure that, you know, you look for the proper advice on how establish that, you know, how to formalize the structure in a way that's not going to put you in trouble. And of course, as you mentioned, there are a lot of opportunities on interacting between, you know, Web3 and the real world, let's call it this way. And without the right structure, you might miss out some of these opportunities. Guys, I think we already getting to the point where we're talking about corporate governance and what we're seeing right now in terms of best practices. So I'll pass along to Daniel to hear. I know you guys are working with a lot of early stage and companies that are in the Web3 space. So, you know, this is not a legal advice, but in general terms, I mean, what are you guys seeing and recommending in terms of corporate governance and tax structure?
That is a good question, Michel. And of course, each case is a case, and the ones that are listening to us right now should not take this first as legal advice, and second as a golden rule that would be applicable to any kind of project, any kind of structure. But as a rule, usually you can split your product between the a holding company, a service provider company, and the one that is going to make the distribution or the offer of the tokens, the crypto. And we need to surpass the understanding that was like in force for quite some time now. Every now and then there is a builder that comes to us and asks, which jurisdiction should I go to make an offering of fungible and no fungible tokens, and where I don't need to qualify for a license. These days are almost over, guys, because we need to separate things. It doesn't matter if you incorporate in a country that no one knows. If you're going to offer for users on United States, on Europe, in Brazil, you need to be in compliance with this country's legislations too. So this is not protection. You are actually burning your money in a structure that does not protect you. So it's very important to understand, I would say, if there is going to be a distribution of profits in the near future or not. This is very important. Where is the place of residence of the founders, so we can understand from a tax perspective. Just to give an example, and I would love to hear Camila on that, how CFC rules could affect the founders of these projects. These are not only talking about the effects of this planning, this corporate planning, tax planning on the founders as natural persons, but we also need to take into consideration from the the company's perspective, what we are trying to do here. Are we going to have a crypto gain? Because if so, taking for an example, I need to choose a place to incorporate a company that will be the holder and the owner of the intellectual property of this project. It would not be recommendable, or I would not advise any company to have an IP held in a company in a country that we don't know how they protect intellectual property. So there are several different legislations that at the end of the day, they come to play. So that is the reason why we gave this name together with Michelle, Camila, and Bruno to this webinar, because people are focusing effortlessly on the business plan. But the way to implement this business plan is totally related to the legal plan of the project. So the way you are going to offer tokens, if you are going to qualify as a virtual asset service provider or not, the kind of token that you are offering, there are so many variables that you need to take into consideration that I would say in the day zero, it's very important to have like a board meeting, if I may say so, informally speaking, between the founders to understand how they see the project, where they want to go, what are the goals they want to achieve, and what they want to do with the money that they're going to generate. In which timing also. There are so many things that I would say there is no specific structure that would be like a goal, a green light to go in every single case. But I would say that when you have your operations splitted, broadly speaking, in this triple structure between holding, service provider, and the distributor of the tokens, usually this is a good way to start, but always having in mind that we need to have substance, material and economic substance in these operations. Otherwise, your planning can be disregarded for regulatory purposes or from the tax perspective too. I don't know, Camila, I would love to hear from you, because thinking about international tax planning, there are so many variables involved that I'm sure that there is no golden rule, but there are some like good hints of where should we go for, what should we care for.
Exactly. The challenges of doing business globally, I think this was something we were going to assess here, but I think anticipating right now it's pertinent. So management, control, financing, protection from liabilities, everything has to be considered, including the personal situation of the shareholders, partners, or whatever is going to engage in the project. Each person is located in a different jurisdiction. Generally, people from around the globe come along together for these projects, and we have to take a look at each jurisdiction rules, CFC rules. In the United States, we have other anti-deferral rules like the PFIC rule. In Brazil, we don't have this for individuals so far, but we have a project coming along. We just don't know the result. So if anyone wants to run some type of Web3 project or any startup project, we highly encourage planning to set up a business in the right jurisdiction to receive all the necessary financing for the project and avoid common pitfalls, especially if we face situations in which the geography factor may play a bigger role, such as where is the company incorporated? Where is the server located? Transfer pricing rules. As for server, we have a great example here. Tons of clients come to us with the Delaware structure, Cayman structure, and a lot of people don't know the consequences of having a server located in Delaware. And I'm going to call Michelle here to this one because it can be quite burdensome. But if you only get this information if you set up the right planning structure.
Yeah, what I see, guys, and correct if I'm wrong in terms of your perspective, but a lot of companies in this space, they come to us, say, hey, we're looking for a jurisdiction to hide, kind of, not to, like to set up our structure in a way that we are not visible. And we try to take that misconcept, say, hey, first of all, these are the rules and you're not doing anything wrong. You can set up this company, as Daniel mentioned. You can put the company in, whatever, Delaware, but if you are going after Brazilian investors or if you are marketing your NFT in India, you got to follow local requirements. So and my next comment is regarding the decentralized aspect, right? Like, because these companies are mostly in the cloud, they don't have physical presence anywhere. And then Camila brought a point that, okay, a lot of times these companies are established in Bahamas or Panama or Cayman Islands, but then they have a service in the US, they are targeting US market, they are going after US investors, so they got to follow US rules. So this is what we see. And again, if you want to do something wrong, if you want to hide information, you normally don't go to blockchain, right? Because you have track of everything there. So cash is a lot more, successful for this type of transaction than blockchain. But again, we need to fight the misconcept and the misinformation, and that's what we are doing here today. And again, I appreciate Camila and Daniel's input on the topic, because, well, when we start asking some of these questions, and then some of the founders, they realize that they're going the wrong direction, right? Like, okay, you have this amazing project, there's a huge potential, and then we start asking, okay, where are you registering your intangible assets? And they don't have an answer for that. Okay, what's going to be the focus of your market? Oh no, we are focusing on, kind of like, we're targeting the global market. We don't have a specific target. Okay, and then we go back to what type of token you have. Is it a utility token? Is it security? And again, our job is to make them kind of start answering these questions, so then we can help in setting up the right structure. As Daniel mentioned, there is no a plug and play here. I mean, this is relatively new, regulatory aspects, tax, everything, so if you're doing something new, make sure that you follow whatever rules applicable to the real world, like just try to be with rules, and, you're gonna, relatively speaking, you're gonna stay out of trouble. So that's kind of like my take on this. And I want to bring to the point here that Camila mentioned, dealing with the centralized aspect. I mean, we in the US, we deal with a lot of e-commerce entities, and somehow we can relate, because a lot of these entities, they are established elsewhere, and they have this web page that they're selling to all over the States, but they're not registered anywhere in the US. And then the States, start going after them, say, hey, you're selling $1 million here to consumers in my state. Where are my taxes? So, like, again, we're not talking about Web3. This is, real economy, real issue, but also applies to, Web3 startups. So again, we are dealing with intangible assets, and the level of complexity here is just kind of like, it blows my mind. But Camila, so share with us a little bit your perspective on regulatory aspects, and how what the governments are doing to go after the companies that are not in compliance with, everything that's going on, and especially on the security aspect, but not only, right? Also on the tax aspect.
Okay, so aside from the attempts to apply all the laws already enacted to the legal relationships we currently have, since the concept of a decentralized environment doesn't really match our current non-virtual reality, one of the biggest challenges governments are facing is money laundering, gambling, know your customer provisions, how we're going to tax everything, and again, as Daniel mentioned at the beginning, security law. Virtual currencies and tokens can be highly used for money laundering and financing of organizations like terrorism, and governments are facing difficulty with compliance rules for these matters. So these tokens and currencies can be highly anonymous and kept in the so-called cold wallets, which are not connected to the internet, making it almost untraceable. We're still talking about a world of arts, digital arts, so high-valued digital arts can call the attention of the authorities for money laundering purposes. FinCEN, if I'm not mistaken, the Financial Crimes Enforcement Network, issued guidance in 2013 or 14, but it was updated in 19, and has treated money laundering practices with a closer look. So NFT marketplaces are a target for this type of operation. As for asset ownership, as Michelle mentioned, assets can be shared in the Web3 and metaverse environment. We have a bunch of assets, virtual assets being created every day, tokens, coins, digital art, and many of these assets, if not all of them, can have an actual value attributable to them, a real value, meaning they are worthy of something, some dollars, for example, in the real world. And all the transactions, the tax authorities from all over the world are trying to cover these transactions and tax these transactions as if these digital assets are treated as tangible assets, personal property, but there's still a lot of confusion on this matter. Which type of income can be capital gain, which type of income can be an ordinary income. So ownership of these assets, management and control of them are an issue. In some way, it is what determines the person entitled to sell it, dispose of it, somehow profit from it, and also the jurisdiction that can tax the owner, for example. So legal enforcement as well. What laws apply to what person? People are sharing the same assets, so multiple jurisdiction participating in the project. Does it imply multiple law? Is it something to be answered for me? I'm going to ask Daniel to give his personal perspectives on this matter. But so far, I think Australia has covered the tax treatment of cryptocurrencies. The IRS has only issued Q&A and some legal perspectives in 2014. In Brazil, we have some new laws, but they're not covering all the transactions that can arise from this environment. So governments are facing all of this, and everything is changing quicker than we can get along with it.
I mean, for now, I think governments are hoping on the voluntary disclosure, right? Like, I mean, in the US, for instance, on the tax return, one of the first two questions, like, do you own, crypto assets? They want to know. And if you put it that you don't, and eventually they find out, you're in trouble. I mean, that's money laundering right there. But I think like they're still trying to figure out how they're gonna, apply all these rules and regulations regarding taxes, compliance, because as we said, everything's relatively new, right? Daniel, your perspective on this topic, please.
I agree with you. Both of you guys, I'd say we could think about, I will not comply with these voluntary disclosure agreements. But imagine that you are a person that has a formal employment where you get like $500 a month. And then you appear in the front of your house with a Lambo, right? People in Web3 love to talk about Lambos. How this person can explain that he or she has a Lambo? So either you have a voluntary disclosure of it, or you don't have the means to prove where your wealth comes from. So if you take, for example, some cases where you have enforcement, because here we need to separate things. We have the conceptual perspective of legal interaction with Web3. We mentioned in this webinar several different legislations that are perfectly applicable to Web3. So general data protection rules, securities legislation, maybe a framework focusing on internet, how just like we have in Brazil, taxation, civil code, Consumer Protection Act, so on and so forth. So conceptually speaking, all of these laws should be applied. The problem is not there. The problem is in the enforcement perspective. And on enforcement, there we may have difficulties from the regulatory perspective for prosecutors, for tax authorities. This doesn't mean that they are not going to catch you, being strict to the point. Because of this example I just gave, people need to understand that they have to prove how they acquire the assets that they have. So one thing is to pay taxes upon transactions. The other one is to comply with disclosure reports. It's very important that you do that. We have frameworks being built, for example, by the OECD. So we have CARF, that is the crypto asset reporting framework, if I'm not mistaken here on the name, but we are discussing that all over the world. But we need to understand that we have the abstract application of laws and the enforcement of them. Last year, I have the pleasure to publish in the Lisbon International and European Tax Law Seminars under the scientific coordination of professors Ana Paula Dourado and Rita de la Feria. And I published a paper with my brother about the challenge from international tax law perspective regarding Web3 phenomena. And we need to understand, very important, that the enforcement, we may have difficulties to track the source of payment, the source of production of ordinary income or capital gains created in the Web3 field. But the nexus on the residence of the person that is owning or getting this income is a very strong nexus in the Web3 space. So we may have difficulties regarding decentralization, and we need also to question ourselves, is this really decentralized? Because there are several projects that they sell themselves as decentralized, but then when you check the tokenomics of the project, there is like a huge bunch of the tokens that are going to the founders. So this is not decentralized, right? Because the other people that is buying and selling tokens, for example, governance tokens, they will never have the power enough to make decisions. That is true also with staking. Staking is a consensus algorithm that stimulates people to get more and more tokens. So it's the capital power that is talking, not the centralized governance. And also when you look to Bitcoin, it's highly debatable if we have something truly decentralized, because as more difficulty mining gets, few people can mine. And there's no problem with that, but we need to understand that decentralization should be a word that we use with cautions, you know, because most of the projects that I see in a daily basis, they are not decentralized at all. And if they are not decentralized, they are application service providers, because I can have connection service providers and application service providers. And if they are application service providers, I can locate the source. Of course, hypothetically speaking, we can have virtual private networks being used. This can be a challenge from the enforcement perspective, but not from the general application of the rules already set in our legal structures in our each jurisdiction. So that is how I see decentralized entities. Usually they are not decentralized at all. And usually you can locate, at least with some specific tool that today we have blockchain forensics, and we can geolocate the IPs behind the transactions. And this way you could say that you can geolocate the source. And being able to do that, you would be able at least to say this jurisdiction, the legislation, the laws of that jurisdiction should be applicable.
Awesome. So I think we are, we still have 10 minutes, so we're going for our final remarks, and then we have time for a few questions. Daniel, just in a nutshell, I mean, we discussed about being global and doing business globally, and I want to hear from you the importance of tax treaties in the Web3 world, and how does it impact, you know, the day-to-day of companies and founders, right? Because again, that goes back to picking the right jurisdictions and tagging along the tax game.
Perfect. I think when we start to debate the application of tax treaties through Web3 projects, this is when things get serious, and you can see that there is a maturity in the discussion. And why is that? Usually people think that going to offshores or to very distant countries would solve all of their problems. But at the end of the day, they need to eat, they need a place to live, and they need to pay these places or these things, traveling, etc. So these projects will generate revenue, profits, broadly speaking, maybe dividends, I don't know. So when we think about tax treaties, for those that are not very into international taxation, and I would, Camila, I think you have some pearls to share with us in this topic, but usually a tax treaty is divided on different topics, different types of income. So with a tax treaty, a double tax treaty, we want to avoid the double taxation and the double non-taxation of specific types of income. For example, profits, yield, royalties, capital gains, etc. Either there is a residual provision about other income that I think will be highly applicable to Web3 phenomena. But also, we use these treaties to understand how someone can be qualified as a resident in a country. Because maybe, depending on the case, and we have digital nomads nowadays, you can be a resident on more than one place. So if these countries, they have a tax treaty, you would be able to claim the application of a tiebreaker rules to understand where, from this perspective of the relationship between those two countries, where you are being considered as a resident. And then you can understand what type of income are you profiting from in your project. Maybe you are staking your coins and then you are generating yield using Aave, for example. Or you are staking Ether in Ethereum 2.0. So it's very important to understand how you are acquiring your assets, broadly speaking, because you can qualify this income in different perspectives. Either if you have a specific entity paying you, maybe you don't have any specific entity and then you have like a DAO and there is only a protocol paying you. It's very strange to say that a protocol pays someone, but in Web3 perspective, we have an evolution from a user-to-user interaction to user-to-smart contract interaction. So we need to question ourselves, who coded, who's the owner, who designed the smart contract, to maybe try to understand the source of payment or the source of production. And if this is not feasible at all, then we can think about, for example, qualifying the income that this person is receiving as other income. But at the end of the day, we need to understand that tax treaties, they are our friends, because if you use a tax treaty in your project, you can have more predictability regarding how your international flow of income will be taxed. Camila, I don't know if you have a different vision for that.
I don't, aside from the issue with the qualification of income, which can vary depending on the terms of the treaty and how internal law faces this type of situation. We don't have a definition for a lot of terms we have like using for years, and with crypto is not going to be different. But I think the major point here is to determine where is the source. We need a source to apply a tax treaty. We cannot apply a treaty if we don't know which state is the state of source. And I think aside from the qualification of income issue, this is the biggest one. We have income from all around the globe. You have the state of residence of the person receiving this income, but if you cannot determine the source, how are you going to apply this treaty? I think source plays a major role here.
And guys, one interesting thing is that during some time we saw a shift of interest in, literally families were relocating to certain countries based on their tax law for crypto, because if you have a significant chunk of Bitcoin, for instance, that you're planning to sell, right? And you basically tax based on your residence. You can pick and choose where you want to pay taxes depending on your circumstances. Of course, if you're a US person, then situations are a little bit different. You don't have the exit declaration in the US like you have in Brazil, and so it depends basically on and again, as Daniel mentioned, you can have multiple tax residencies, so it's quite challenging. But we saw it quite some projects that people were coming to us saying, hey, if I relocate to, specific country, and then I have, a transaction happening during that period, am I going to be able to take a benefit of that tax, exemption or so on? And that goes back to, tax planning 101. Well, you cannot isolate that transaction and just look at that transaction specifically. But if you follow the rules and you qualify as a tax resident of that country, then yes, you're going to follow their rules. But now we see some of these laws changing again and kind of like going back to, more what we say, that would be kind of like the normal stage, if you would. But again, these are some of the challenges that we're seeing on Web3. And I'll pass along to you guys for final remarks. Appreciated the time. I think I learned a lot here. I hope you all enjoyed. So thanks so much. Daniel, final remarks?
I believe, first of all, Michelle, I'd like to thank you and Bruno, Camila, Aline for the invitation. It was really nice to chat with you guys about this topic that I really in love with. And I believe that when we think about Web3, we are like evolving on the creator economy. So we should not disregard the importance of the legal perspective of these projects. And I'm not talking here as a lawyer, because we have, like, for example, me, Camila, Michelle, it's Drummond Advisors, it's VDV Law Firm, we are all in the legal system. No, we are not trying to like make legal more important than the product. That is not true. We need to have a skeptical view, in the sense that we need to understand that blockchain is not another planet. So it is under the traditional legislation, and the law was not built to have specific provisions for every Web3 phenomena. We have some residual rules that they are encompassing Web3 phenomena. So having this in mind, we have to move forward from a business plan that has a nice chat with a legal plan in order to protect your project and to protect yourself. I think this is the main takeaway from my perspective on this nice webinar that we had. So Camila, please.
So guys, as Daniel mentioned, basic contractual law can be applied to blockchain relationships. Basic corporate law can be applied to this relationship. So planning is highly advisable if anyone wants to run some type of Web3 project. So the choice of jurisdiction, how you're going to manage it, control it, finance your project, and also split some assets to protect the entire project from liabilities. Everything really reflects the real world somehow. We know we have some differences and difficulties, but it kind of, as I mentioned previously, it is a social interaction in the blockchain environment. So it reflects society, and laws and regulations, they were enacted somehow due to the social interactions. Laws were born for some reason. It's not going to be different in the blockchain environment. Residence can be traceable. Source is kind of hard to trace, but we're working with it, and let's just hope for the next steps. This conversation really opened my mind for possible academic work to be developed. I have some new ideas. We can discuss it over time, and let's just wait for the next chapters.
All right, guys. Thank you so much. Hope you all enjoyed. Have a good one. Bye.